Hi, thanks for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Saul Glazer, a Wisconsin construction lien law expert. Today's webinar topic is a contractor's, subcontractors, and suppliers step-by-step guide to getting paid. So without further ado, I'd like to introduce the fabulous Saul Glazer.
Good afternoon, everyone. Hi, my name is Saul Glazer. I am an attorney at a Madison law firm called Axley Law Firm. I've been a lawyer for 34 years, and I've spent the last 20 or so practicing basically exclusively in construction law. I've helped out a lot of contractors over the years, done seminars all over the state for people who are part of the Wisconsin Builders Association. And so today, we're going to talk about liens, and we're going to talk about lien waivers. And there's only 3 things you need to know about liens, and we'll go through the slides. Normally, I used to do the seminar in about 8 hours, and then I've done it for 1 hour. Today, we're going to do it in about 15 minutes. If you have any questions that I don't get to, you can always feel free to shoot me a generic question after the fact via email at sglazer@axley.com. And I'm going to be going through some lien forms today. And if you want copies of those, you can reach out to Jessie and she can get you those lien forms. But if you do ever send me an email, because I represent a ton of different people, never put anything confidential in any email. You can ask a generic question if you want, but if you need something which requires you to reveal confidential information, do not send it to me without first talking to me over the phone, because I have to make sure that I'm not representing, that I might be representing the person that you're building something for, or some subcontractor on a job, or maybe you're the subcontractor and I might represent the general. So never share anything confidential with anyone unless you know that you actually have an attorney-client relationship. So with that, I'm going to pop through. At the end, there's going to be a question box, but again, if we don't get to the questions, if you think of something tomorrow or the next day and it's just a generic question, send it to me. You can also try calling me as well. You can Google me if the phone number is not on here, but I think it probably is. So today we're going to talk about liens in general, and then we'll go through the slides, and at the end we're going to talk about lien waivers. So the first thing you need to know about with liens is that there are people that do things called no lien contracts. So you could be a subcontractor on a job and not realize that the moment you sign the subcontract that you waived all your lien rights for that project. So whenever you're doing any kind of job, period, you got to read everything. You got to read everything you're signing, and people put weird things in weird places. So just because the contract looks like it's a normal contract and it's the same standard contract you think you signed 100 times, you got to read it cover to cover, because it could be in the 14th paragraph, buried in some part that doesn't make any sense. There's something like saying like no lien, or there's something like if we don't get paid, you don't get paid. And so you need to understand clauses in contracts. And if you don't understand the clause, don't just say okay and do a Homer Simpson and sign the thing. If you read something and it doesn't make sense and it's not in English, you got to find out what it is. And so you should reach out and have an attorney guide you through something, because you need to have a general understanding of the law if you're going to do construction, because construction is a very dangerous business. Right now, I'm in the middle of a mediation right now where I represent a contractor, and we're talking about millions of dollars at stake, and it's all about what people signed, when they signed it, and what they agreed to. And one project can ruin a contractor. You can have the most perfect record, and one contract can ruin it, and one owner can ruin it. And a lot of times the problem is the owner goes ahead and does something, but they don't have enough money, and you have to understand how the money flows. And if a bank loans money to an owner to build something, and there's not enough money to pay out everyone, the bank's loan and their mortgage takes priority to everything. So even if you have a lien, there may not be equity left in the project for you to get any money out of. So you're only going to need to remember 4 things from today. Number 1, read your contract cover to cover. Number 2, there's 3 types of steps in the lien process, and that's what we're going to go through. Actually, I guess you're going to need 5 things. And the last thing is you got to be careful about lien waivers. So there's two types of people under the Wisconsin lien law. There's the prime contractor, which just means that they have a direct contract with the person who owns the property, or if it's a tenant build out, they have a direct contract with the tenant that's building it out. Or there's everyone else. And everyone else in normal parlance would be a subcontractor or supplier. And in Wisconsin, there's multiple tiers you can go down. So you could be a 7th line supplier and still be able to lien a project if you've done the right steps. Other states, you have to be either a 2nd tier or a 3rd tier to lien. And I guess one thing I need to cover is Wisconsin lien law is Wisconsin lien law. If you're doing work in Illinois, everything I say today may or may not apply. So don't go into Illinois or Indiana or Minnesota and think that the Wisconsin lien law is going to be the same. Every state has different lien laws. And so you just need to know the same thing for Minnesota that I'm talking today as it relates to Minnesota law before you do work in Minnesota or vice versa. Okay, so in Wisconsin, if it's a residential project of 4 units or less, it's a residential project, 4 units or less, no commercial component. In that situation, technically there's a 3-step process. If there's any commercial component, or if there's more than 4 residential units, you skip the first step. Now that doesn't mean that you don't put it in your contract if you're a general contractor, but if it's got more than 4 units, or it has some non-residential component, it has a commercial component, you skip number 1. And step number 1 is the identification notice. And the reason why you have an identification notice is because it tells the person that you're building, hey, guess what? I'm doing work here, and if you don't pay me, I can lien your property. So so it's a consumer protection thing for residential projects. So if some homeowner decides to put a deck on, they don't all of a sudden end up with a lien claim without knowing that they had a warning. Okay, so if it's got 4 units or less and non-commercial component, step 1 is identification notice. All right, and then we'll get into whether or not there's ways around it. But if you're a subcontractor on a residential job and you don't do the identification notice within 60 days of the start of the job, you pretty much lose your lien rights unless you then subsequently do an indemnification notice down the line. But then the lien rights are only to the extent of any work performed after the identification notice showed up. So if you're doing subcontract work on residential, you got to get that identification notice out. Okay, so the timing is, so prime contractor has to do it within 10 days, or if there's a written contract, they got to put it in the written contract, and it goes to the owner. Subcontractor within 60 days of start of work. Big mistake subcontractors make is they give the notice to the contractor. The notice does not go to the contractor. It has to go to the owner, because the point of the identification notice is to warn the owner that they can be liened. So giving it to the contractor doesn't help the owner. So if you're a subcontractor on a residential job of 4 units or less with no commercial component, you got to give the identification notice if you want to have lien rights. If you don't, you lose your lien rights. Again, there's an exception after 60 days, but you don't want to be there. And then the form, if you have the forms, you don't need to worry about the type and everything else. The other thing is how you get it to the owner. So the lien law has specific service requirements, and they apply to every step. And either you have to hand it to the person, which is personal delivery. You could use Federal Express if you have a signature requirement, or certified mail. Most people use certified mail. Certified mail is great, except guess what? People don't pick up certified mail all the time. So with certified mail, you can send it, but a lot of times it bounces back, and the law is unclear if it bounces back, whether or not that's service or not. But you have to follow these service requirements, either personal delivery, certified mail, or some other method where the person writes and says, yes, I accepted it. So if you did FedEx with a signature requirement, that would work. But that can get tricky because FedEx doesn't always get a signature when they should. So make sure you follow the service thing, certified mail, return receipt, and then you get it back. But if they don't collect it, then you have to figure out something else. You could have a share of service if you had to. The easiest thing would be just to hand it to the person and then have them sign that they got it, and then there's no dispute. If you don't do an identification notice on a residential job of 4 units or less, and you're a prime contractor, you can still get away with it, but you have to pay all your subs off before you can lien the property. So a prime contractor on a residential job of 4 units or less with no commercial component can skip the identification notice, not not recommended, and there's no reason not to put it in your contract, but there's a way out of it. If you're a subcontractor, there is no exception except for the 60 day. If you did it after 60 days, you can start the lien process then, but then, you know, most subs might have been in and out of a project within 60 days. The other thing is subcontractors, you have to give 2 copies of the notice, and the notice itself says, you know, you're giving 2 copies. So remember, you got to print out 2 copies. For some reason, the statute wants you to give 2 copies of everything. And again, the size, you're not going to 8-point type. You can't even read it, so it's going to be more than 8-point type. So for the prime contractor, you put it in your contract, unless if there's an oral contract, then you do a separate identification notice. But you shouldn't be doing an oral contract with anyone anyway these days, if you're a prime contractor. So here are the forms. If you want to get a copy of the forms, you can reach out after the fact and we can get you these forms. So this is the first step in the process. This is if you're a prime contractor and it's not in your contract, this is what you'd send, you'd give the owner. And this one says 2 copies and tells you how you're giving it to the person. And then you sign it, fill it out. And if you're a subcontractor, this is a subcontractor identification. So step 1, identification notice. Never skip it if you're a subcontractor on a residential project with 4 units or less. All right, step 2. So again, yeah, if you're a prime contractor and you skip it, there's a way to do it, but just put it in your contract so then you don't need to worry about making sure you paid every supplier and everything else before you can leave the job. And then for a late notice for subs, you can serve it, but then it doesn't start triggering until 60 days later. Okay, so then step 1, you've done the identification notice if you need to. If it's a commercial job or it's more than 4 units, you can have skipped the first step, and then step 2 is the notice of intent to lien. For that, it has to be done more than 30 days before you actually serve your claim for lien, which gets filed with in the county where you're doing the work. If you don't do a notice of intent, no matter who you are, you're done. And again, with this one, you got to do the same kind of service. Here are the 2 forms. This is the prime contractor notice. It basically says, I did this work. I need this money. If you don't pay me in 30 days, I'm going to lien your property. Subcontractor notice of intent, same thing. And you got to follow the same service requirements that you did up front for the identification notice. Third step is the claim for lien. It has to be done 6 months from date of last work. Date of last work can include punch list work. It cannot include warranty work. So if you're getting 3-4 months out on a project and it's non-residential, you're fine. If it's residential, you would have better have done your identification notice. But if you're 3 or 4 months out and you haven't been paid, it's time to decide whether or not to do a notice of intent. You always want to do it early because there might be service problems in terms of letters bouncing back. But you have to have the notice in 30 days before the claim for lien, and the claim for lien has to be done within 6 months of date of last work. And then after you do the claim for lien, you got to serve it on the owner within 30 days of that, or you don't have a valid lien claim. And here's the form that you fill out for the claim for lien. For the prime contractor, again, you can get copies of these forms, and here's for the subcontractor claim for lien. The most important thing on this is you have to know who the owner is. Sometimes they tell you who the owner is, but it's really not the real owner. So to know who the owner is, you actually need a title search. You don't need to do a title report, which costs like $250, but you need to get a copy of a deed. Some places you can get a deed online. Other places you have to work through a title company. And sometimes the ownership changes. And if the ownership changes from the time the start of the project to when you finish, you need to know who the first owner was, and you need to know who the last owner is, and you need to send these notices to both owners as it goes away. The last point of today's seminar is lien waivers. So if you waived your lien rights, you can't lien the property. And a lot of lien waivers in Wisconsin say something like for value received. And what that means is you're admitting you got paid. And if you got paid, even when you didn't get paid, you waived your lien rights. So never sign a lien waiver that says for good and valuable consideration or for value received, because as soon as you sign that, even if they give you a check, you've waived your lien rights if that check bounces. So always demand that your lien waiver says that is conditioned upon payment in good funds. And that means that unless you get paid in good funds, meaning real money, you don't waive your lien rights. The other thing to be worried about with respect to lien waivers is that a lot of them also have buried language about releasing claims. And that means, like, you might sign a lien waiver saying, I waive my lien rights, but it may also say any other claims for change orders or anything else are waived. And then also you have to worry about retainage. And so you want to keep the lien waiver not to waive your retainage as well. So understand what the amount of the lien waiver is for, and understand what it's waiving, and reserve your rights for retainage and any finalized claims, and never sign something that releases everything, because then you might have just waived a bunch of change orders on a project. But make sure you never, ever sign a lien waiver that says for value received, or it says for good and valuable consideration, because that means you've accepted money even if you haven't gotten paid, and that means the lien waiver is valid. As soon as you sign a lien waiver in Wisconsin, it's valid unless it says it's conditioned upon payment in good funds, which means unless you get paid the amount of money that they say they're going to pay in the lien waiver, then the lien waiver is valid. And lien waivers are broadly construed, so they apply to everything unless you've limited it. So make sure you limit it to what you're actually waiving lien rights to, like date of last work through September 1st, or for this pay application. If it's a broad lien waiver, sometimes people will sign a lien waiver. The first lien waiver on the project might say they've waived lien rights for the entire project. And again, like a regular contract, if you have questions, you don't understand what it means, call a lawyer to figure out so that you understand what lien waivers mean before you sign them. So you got to read everything cover to cover. Don't assume just because some guy's nice, they hand you a contract that even if it's a short contract, it may have terrible language in it that might hurt you. And there are a lot of bad contracts out there. I read contracts all day long as part of my job, and every day I'm having to strike clauses and rewrite things because people want people to sign things that are unfair. And you always want to be in a deal that's fair. If you're working on a project where the guy's trying to do something that's unfair, the project's going to have other problems, because if the guy's cheating you on the contract, they're probably going to cheat you somewhere else. And it's shocking how many people out there expect you to do something for nothing and not pay you. There's nothing worse than doing work for someone and then getting stiffed at the end. It can ruin a contractor in one job. So if you do sign a lien waiver, if you have open change orders, make sure that you're saying this does not waive change orders. You want to put in extra language to make sure that you're limiting the lien waiver to what you're actually trying to waive for, the payment for this work that's been performed over this period of time or this scope of work. And if you do all work to a certain date and you don't reserve retainage or extras, then you basically waive your lien rights for any extra claims, and potentially there might be release language that would actually waive the change orders as well. So with that, I just gave you an 8-hour seminar in 18 minutes. Again, I used to do this in 8 hours. Just remember 3 things as it relates to lien waivers. Identification notice, if it's 4 units or less, no commercial component. Always best practice for both prime contractors and everyone else to do the identification notice. Has to go to the owner, has to be served properly. After that, once you finish your work, you have to do the notice of intent within more than 30 days before the claim for lien filed. So technically, maybe 3 or 4 months out, you have to send out the notice of intent. It has to be properly served. And then you have 6 months from date of last work to file the claim for lien within the clerk of courts where the work is located. And then after that, you got 30 days to file to serve that on the owner. Again, same type of service. Then all that's done, then you still have to foreclose on a lien. You got 2 years from the date the lien claim has been filed to foreclose. At that point, you're going to need a lawyer anyway. And best practice, if the lien's of any value, you're going to probably want to get a lien lawyer to help you out once you start into the notice of intent spot. If you understand lien law, you're safe on the identification notice piece, but you got to make sure you actually know who the owner is. So, and do some investigation, figure out who the owner is. So with that, if there are any questions, otherwise we can you can send me emails later on. And I think there's another seminar maybe 6 months out from now that's going to also give you guys some more information on what to do. And the other thing is this seminar now becomes a video that you guys can watch at a subsequent date if I talk too quickly to get through in 20 minutes or less.
Hey, Saul, I apologize. It looks like I had lost
Excuse me?
connection here for a moment.
Are you still there?
I just want to make sure that we're answering questions. Have you been able to get through the slideshow?
Yeah, I'm through the slide. Yeah, I just finished.
Saul, can you hear me?
Yes, I can hear you.
Okay, I apologize, you guys. Like I said, I lost connection here for a moment. The audio went out on me. Okay, so I do see there is one question that popped up in the chat. I just want to make sure that we're going over that real quick. It just said, can attorney's fees and filing fees be included in my lien amount?
Okay, so that depends on whether or not, it depends what level you are. And so, so what you do is you put attorneys. So if your contract has an attorney's fees clause, you can recover your attorney's fees. Whether or not it's lienable or not, it depends on if you have a direct contract with the owner or if you're a subcontractor. A subcontractor's attorney's fees are not awardable against the owner. But typically, what I put in the actual claim for lien is I'll say plus attorney's fees as allowed by law. And so, but it's just in your contract, if you have an attorney's fees clause and it's just between you and the owner, then you can lien for the actual amount of the attorney's fees as well.
Okay, thank you so much. And then the other question that was posed is, how long is my lien effective?
So once you lien the property, it's good for 2 years. You have to foreclose, you have to start a lawsuit within 2 years of when the lien is filed. So you have 2 years from the date the lien is filed with the clerk of courts. And you have to start a lawsuit to foreclose on a lien. So one thing that happens a lot of times, they'll file a lien and do nothing with it because maybe it's a $10,000 lien, but then the owner wants to sell the property. And so all of a sudden, 6 months later, I get a phone call, hey, I'll pay you 10 grand to get rid of this lien. And so one of the advantages of a lien is that even if you don't get paid immediately and you don't want to spend the money on a lawsuit, it can prompt someone, if they're trying to get refinancing, if they're trying to sell a property, or if it hurts their credit, that they'll turn around and try to get rid of it even without you doing anything.
Okay, all right, well, perfect, thank you. All right, now if anyone does think of a question that wasn't addressed, please feel free to reach out, send me an email. We'll be sure to answer any questions for you. All right, Saul, are you able to go to the next slide for me?
I'm on the last slide. Oh, there's one more, sorry.
Oh, yeah, so this is just a little pop quiz. Take a look at this. If you guys are able to answer in the chat, the correct answers, we'll send you over a little bit of a SunRay gift for you guys for interacting with us. So take a look. I know that Saul went over some of this information, so hopefully you'll be able to remember that and pop it into the chat for us. All right, Saul, can you go to the next one for me, please?
Sure.
Go ahead and take a look at this, scan the QR code for us. Much information on here for you. There's deadline calculators, project information sheets, state lien laws, depending on which state you're in. So like Saul mentioned, Wisconsin versus Illinois versus, all these other states, every state has its own lien law rules. So you can kind of check on here to see what laws will apply to you depending on what state they're taking place, the job is taking place in it. So go ahead and scan that and check that out. Go ahead and go to the next slide for me, please. Also, if you guys are needing collection services, please go ahead and give us a call and we will help you out. And then go ahead and go to the next one for me, please. All right, the next seminar, the next webinar with Saul is going to be on December 10th. That's going to be protecting against price escalation and unavoidable delays in materials. So go ahead and register for free at sunraynotice.com/education. And then go ahead and go to the next one for me, please. All right, give us a review if you don't mind. We appreciate all the feedback we can get. Go ahead and scan that QR code. And then one more slide for me, please.
I'm gonna give them another second to scan that QR because I'm slow. I'm always slow when I do that. So.
Well, thank you. I appreciate that.
Okay, now I'll pop it.
Okay, perfect. All right. And with that, that is all we have for you guys today. Saul, again, you were incredible. I know you jam-packed so much information into the last 15, 20 minutes, so we really do appreciate it. Thank you so much to everybody that attended. We hope to see you guys at our next webinar. Thanks again, everyone. I hope you have a wonderful and sunny day. Bye, guys.
Yeah, and Jesse's down in Florida, so she's having a really sunny day.
I
Take care.
am.
Goodbye
Thanks,
to you,
guys.
Jesse.
Have a
See you later.
good day. All right, bye-bye.